Hi, everyone. Just going to give it a minute as usual for people to get in here. I am on my old ancient laptop. Mine is in for repair, and it's taking longer than I thought it was going to. So me looking at this video right now, the color looks terrible. It looks really washed out. So I don't know how it looks to you guys, but this is definitely not my favorite way of doing this. And hopefully I'll get my laptop back soon because this looks terrible. Hey, Tiff. Hi, you guys. As I was just saying, my laptop's in for repair, and I'm using this old ancient thing, and I'm just hoping that it has enough battery life to get through one video. It is super humid today, as you can tell from my hair. Oh my gosh. Thanks for joining me. It looks fine. Okay, I just know for, like I said, for me, it looks terrible. It looks muted and it looks like I'm gray. I don't know, maybe that's a good look for me. Who knows? Hey, Allie. Okay, so I need to get started right away. I actually do have kids that'll be walking in at some point, and there'll probably be noise in the background, so I want to try to get as much as I can done, done before they get home. So, hi, Sandy. So the first thing I'm going to talk about, and I don't want to spend a lot of time on it because honestly it's just depressing, is the decision in Brendan's case. I actually planned on doing a video on Tuesday. I needed a day just to to deal with it. And then then I was having issues with my laptop, and then my internet went down yesterday at about 4 p.m. and I just got it back this afternoon, and I don't know how I survived without the internet. I really don't, because it was just really annoying. I had to do everything on my phone. So I am here today now, and I'm finally going to talk about this. Now, obviously, everybody was extremely disappointed in the decision of the Supreme Court, but I guess I was a little taken aback about some of the reactions to it. I mean, I understood disappointment and feeling sick and angry and all those things, but some of the comments about, Supreme Court must be corrupt, and it was about politics, and I was like, oh God, no, it wasn't. And that really frustrated me almost as much as the decision itself. I get that people want to go somewhere with their frustration and their anger, but I guess it kind of surprised me because we have been talking about AEDPA, AEDPA, the Anti-Terrorism Effective Death Penalty Act, since we started talking about Brendan's case being in federal court and how that was always going to be a huge hurdle to overcome. And I think people seem to forget about that once it got to the Supreme Court. But those rules still applied, and that was going to be a huge issue. And and then you add to the fact that the Supreme Court reviews 7,000 to 8,000 petitions a year, and they usually grant about 75. That is such a small percentage. And then habeas petitions on top of it. I don't even know if they had a habeas petition granted this year, and I don't know if there's any granted for next term yet. I don't think there are. So I mean, that's even rare. It's a fraction of a percent that of a chance that it would even get heard. So I know that we got our hopes up a lot because they really did have a good case. And I did share with everybody, showing how a lot of the legal community was saying this is why they should hear it. And I got caught up in it too, because I really think I convinced myself that he had a chance. But I also read a lot of legal blogs and from legal scholars that said that he wasn't going to get granted. And I just don't share that stuff because I know it depresses people, and it starts with people getting upset, and I don't want to do that. But that talk was out there, and by people who know what they're talking about. Now, again, if the court was corrupt, they wouldn't be saying that. Okay, so the Supreme Court does not give a reason as to why they deny it, and I know people were upset about that. And one person said, like, how long can it take to give a reason? Again, 8,000 petitions a year. That means I think it averages out to like 32 petitions a day that they would have to do a write-up for on denials. It's not possible. They just don't. It's not what they do. Now, the problem is that we don't know what the vote was. We have no idea. It could have been 0 to 9. I mean, none of the justices could have voted to hear the case. And then, people start talking about politics, and everybody knows in my group, I hate it. Don't bring it up in my group. If you want to get on my bad side, start bringing that stuff up. My corruption and politics, bring it up in my group, and you're going to get on my bad side. But, you know, and again, we have 4 liberal justices in the Supreme Court right now, and Brendan only needed 4 votes, and he didn't get it. So that means at least one of the liberal judges or justices ruled against him. Now, there have been times when justices they feel very strongly, and they will write like a dissenting memo saying that they would have granted cert. That did not happen in this case. So again, it's nothing that anybody obviously felt that strongly about. Now, the reason is because we sit there and we look at it. How can they do this? How can they not see that there was a problem? That is not the issue. The issue is whether they have the power to do something about it or not. And that's where EDPA comes in. Because again, EDPA, 1996, this was enacted by President Clinton. It's been around for 22 years. Okay, it's been around for a long time. It took away a lot of the federal judiciary's power when it comes to state convictions. It's not enough to say we don't agree with their decision. It's not enough to say we think he's innocent. We think his rights were violated. They can't overturn a conviction just for that. They have to believe that it was a completely unreasonable decision. And again, since you already had, you know, 4 judges in the Seventh Circuit think that it wasn't unreasonable, you know, the chances are you're going to find more justices that are going to think the same way. They're already showing that some people do think it's unreasonable. The problem is that what habeas does, or what EDPA does on habeas review, and we've talked about this before, so I'm going to try to go through this quickly, is that it has to say that it was an unreasonable application of clearly established Supreme Court law. And that was the sticking point. And the state, I thought their arguments were crap, but they only needed to make one argument, and that was EDPA. And that was all it took. It didn't matter that their briefs weren't, you know, especially well written, or they weren't that great. They had EDPA on their side. And it just says that you can't change the law at all. You can't expand on it. You can't do anything to it. You have to take the law that's on the books and say, did they unreasonably apply this? And I know we all wanted them to set a precedent. I wanted them to set a precedent. But realistically, they're not supposed to on habeas review. It's just not what they're supposed to do. And so it gets a little frustrating because Brendan's team did a wonderful job. And this is when the petition first came out, I said that they streamlined it to focus specifically on the special care issue. They were saying, we don't want to rewrite this law. We don't need you to expand on it. We need you to tell the courts that they need to start enforcing it. We need you to tell them that these laws have been on the books, but you're not consistent with how you're handling this in the lower courts. So that's why they made that argument, is because if there was any hint that they were asking them to change something, it was going to get denied. And, you know, so then asking them to set a precedent regarding police practices and writing of the opinions, you know, more detailed opinions, that is all something that is really not supposed to be done on habeas review. And again, a lot of people were hoping they would do it just because it's time. It needs to be done. But when it comes down to it, they felt like this is not the right vehicle to do it. You know, and obviously it's a huge loss for Brendan. It's not a complete loss for the juvenile justice system, though, because, you know, everyone was put on notice that this is going to come up again. You know, and now somebody that has a chance on direct review will probably get the kind of support that Brendan got just to change this law. So it's not a complete loss in that respect. And when people were asking what they should do, whether they should call the White House, no. Call the judges, no. Okay. The only thing you should be doing if you really want to do something is write your congressman. If you really want to write the president, don't write him, ask him to pardon them, because we've said it 1,000 times. The president does not have the power to pardon a state prisoner. They just don't have it. It doesn't matter who the president is. They don't have that power. There have been petitions in the past, or sorry, I got to back up. I did tell people, you know, contact the president, write Congress about EDPA. It needs to be repealed. It needs to be amended. It needs to be changed because it's almost become obsolete as far as giving relief to state prisoners. And the problem is that, again, it's been on the law. It's been on the books for 22 years. Okay, defense lawyers hate it. They've hated it for 22 years. It's almost impossible to change. And the reason is states love it. Like I said, the state didn't even have to make a good argument. They had it on their side. The law was on their side on this one. So the states are not going to give it up without a fight. Okay, the states are not going to sit there and say like, oh yeah, no problem. We're going to give some of our power back to the federal government. Not going to happen. You're essentially asking the federal government to go against all 50 states. And that is a juggernaut of an issue to deal with. And that's why it's unfortunate that I don't know if anything will ever be done. Maybe eventually, once all these wrongful convictions are just adding up, maybe finally somebody will do something about it. But it really is unfortunate, because the writ of habeas corpus used to be known as the Great Writ. It was the saving grace for prisoners that had no other options. And now it's almost impossible to get a conviction overturned that way. And the thing is that if the case had been on direct review, the standard of review is different. It's de novo. It's not AEDPA. And so they could set a precedent. They can look at the case on direct review. So some people ask, well, why didn't they go the direct review route? Now, when I say direct review, what I mean is that Brendan got his decision in the Court of Appeals, the state Court of Appeals, and then he petitioned the state Supreme Court to hear this case. They denied hearing his case. After that decision comes on, you have a choice. You can try to file a writ of certiorari with the U.S. Supreme Court and ask for direct review of the case. Or you have a 1-year time limit to file a petition for a writ of habeas corpus in federal court. Now, hindsight is 20/20. I mean, obviously, if we'd known how things were going to go down, maybe direct review would have been the way to go. The problem is that if you try to petition the U.S. Supreme Court, you know how long that process can take. The time to file a habeas petition is not told while you do that. So if you do get granted review, you're going to run out of time. It's not like you can lose in the U.S. Supreme Court and then file a habeas petition. You don't have time to do both. You have to choose. And even though the standard of review is much stricter under habeas review, you know that it is going to get looked at. When you file a petition for a writ of habeas corpus, the federal district court has to review it. If you just go and try to petition the U.S. Supreme Court, they can do what they did this time, not even agree to hear it, and you're done. There's nothing else you can do. If you go the habeas route, they have to look at it. And even if you lose, you can appeal it to the Court of Appeals. If you lose again, you can appeal it to the Supreme Court. So you just have more options. And Brendan's team had no way of knowing going in the type of support that Brendan was going to get. His habeas petition was filed, I believe, in October 2014, so over a year before Making a Murder came out. They could not have possibly foreseen they were going to get the amount of support and national attention that they ended up getting. If they'd known that beforehand, maybe they would have tried to seek the direct review route. But, you know, like I said, hindsight's 20/20. They would have no reason to think that that would have ever happened. And so that is pretty much where that stands. I'm trying to go through it. I'm always using my touch screen on my other computer, and here I have to actually use a stupid mouse thing. Hi, everybody. I'm talking, so I'm not scrolling through the comments. Abolish EDPA. Yeah, I agree, Lynn. I wish we could. It's just unfortunate that that's just, you know, Kim Kardashian probably won't help us either. How can we get rid of EDPA? Like I said, you can try to write somebody, but good luck. It's going to be difficult to get rid of it. So what's next for Brendan is that he can file a petition for post-conviction relief, which is called a 97406 petition in the state court, which is exactly what Steve is in the middle of right now. So that is that's his next option. It's going to take some time. It can only be based on newly discovered evidence. So obviously his team has been completely focused on the false confession. So they need to regroup. They need to plan out a little bit. They need to review all of the trial evidence. They need to review any new evidence, including whatever KZ is willing to share, and see what Brendan's best options are for filing claims for post-conviction relief. So that's going to be a ways away yet. Oh, no, I didn't say it's rare to seek direct review. I mean, but I think that was kind of implied with why I said, like, there's really a huge downside to seeking direct review, but you know, it can work, but it's granted even rarer than just any normal petition. So yeah, so as I said, it's not the ideal solution. And like I said, had we known, and the other issue, the other big issue why it was probably denied is that the Supreme Court usually stays away from fact-bound cases. They don't like to get involved in fact-bound cases because the trial court is the fact-finding court. just like what they're doing with Steve's case right now in the Court of Appeals. They remanded it back to the trial court to evaluate the CD and the potential Brady violation because they are not a fact-finding court. They are a review court. And the same is true with the Supreme Court. They are a court of review. They are not a court of fact-finding. And so when it comes to a case where it's a matter of, is he telling the truth? Is a valid confession? All those issues involved, those are facts. And those are things that a jury is supposed to decide. So they try to stay away from those cases. Now, again, on direct review, I think they would have been willing to overlook that point just because this issue has not been addressed in so long. So I don't think that would have been as big of a hang-up as it normally would be. But again, EDPA was the big thing, nothing else. I mean, or like that issue, but EDPA was the biggest one. Okay, so are there any questions about Brendan's case? I just want to move on from it because, like I said, it's depressing. I just haven't felt good about it. I mean, I got frustrated by the comments because to me, it just added to my despair. I think some people look at it as like they want to vent, they want to complain, and honestly, that's what makes me want to quit. I seriously wanted to quit the internet on Monday and Tuesday, really, because it just frustrates me. Sorry, and I know I get short with people. I get a little bitchy at times about it, but I want people to understand the reality of why these things happen. And not just assume everything is always because everybody's against the guys. Somebody had asked me with regards to the motion that KZ had filed, if it's this common for a lawyer to always get rejected. Yeah, it is. It's very common. That again, the system is not designed to make it easy for people to get out. You're gonna lose most of the time. It's just how it's designed. And we really don't want it to be easy for them to get out. We need to take off those glasses, that lens of wrongful conviction, and look at it just in the broadest sense. We have 95% of the people in prison are where they belong, and we'd like them to stay there. And you don't want to make it easy for them to get out. And that's why I'm such a big proponent of things like conviction integrity units and things that will give prisoners another avenue if they are wrongfully convicted than going through the standard appellate system, because it is long, it's drawn out, it's not easy to win. And and again, it shouldn't be easy to win. It really shouldn't be. But it gets very frustrating in cases like these guys. So and we have to take the good with the bad, and we have to just keep going. And Kathleen has said it so many times. It takes years to overturn a conviction sometimes. Especially when there isn't any scientific evidence or any DNA that can just make it cut and dried. Yeah, this person's innocent. Somebody else committed the crime. It takes a long time. And it's not just because the courts are slow. It's just because, she's investigating. She's been investigating for 2 years, and she's still investigating. She's not done yet. She's going to keep investigating until she doesn't have anything left to investigate, until he's home, or he's out. She's going to keep going. And so that takes time too. So it sucks. We hate waiting, and it's one of those things that I said that it's funny how the guys seem to take this stuff so much better than we do. They just take it in stride. It's because they've had 12 years, and for Steve, 30 years of bad news. I honestly said I think they'd be surprised if they got good news for once, because I hate it that they're used to it, but they are. It doesn't, this one probably hurt a little more for Brendan because he's been in this particular petition for 2 years, or 3, almost 4 years. And so it was the finality of it, I'm sure, was really hard on him. But I also know that Brendan has an amazing ability to keep his chin up. It's crazy. That kid is it's crazy. He's amazing. So, okay. So are there any questions about Brendan's case before I move on to Steve's? And if I'm talking really fast, it's just, I'm sorry. I talk fast. Everyone knows that. Okay, so I'm going to move on to Steve's case. Now, I really was confused. I was kind of surprised by the confusion yesterday. And when I had posted that there was an objection, people were taking that as it was denied. And I would say that the court denied it, if that's what happened. It said the state objected to Kathleen's motion. And then again, people get upset about it. And I'm like, why? Would you not want her to have the same option if the state filed something to object to it? It's like, I get very frustrated when people think that only one side should be allowed to do things. Again, you got to take the good with the bad. If Kathleen has the right to appeal, well, then they should have the right to appeal. We don't like it because that's not what we want, but you can't sit there and say it's unfair when it, when it goes against you. You know, it's the system. That's how it is. You know, you just kind of have to take it as it is. And so, of course, the state was going to object to it. And then Kathleen filed a reply today. And this is where I tell my little disclaimer again. You know, like, I would love to be able to sit here and tell you this is going to win. She's going to win on this motion. I would love to tell you that. Maybe I'll just keep my opinion to myself and just lay it out for you what the law is on this. But I don't think she's going to win it. I don't think she has the legal standing to win it. And yet, you know, like I said, I saw people complaining about, oh, they're just doing everything to kick you down. Okay, we know Kathleen is a great attorney. We know that, you know, she knows what she's doing. But, you know, that doesn't mean that everything she says is going to be correct. You know, and sometimes lawyers do things just to do them. You know, like she's giving it a shot. Doesn't mean she even necessarily thinks she's going to win it, you know, but she has to try. It's one of those things, you just kind of throw the kitchen sink at it and hope something sticks, you know. And so, but then people get all upset about that this is going to be denied it without even any consideration to whether the legal standing on this, if she has a legal leg to stand on in this one. And I, you know, my opinion is that the law's against her on this one, but, you know, anything can happen, you know. And again, I'm not saying it because I want that to be the case. And most people in my group get it. They get me. They know that I say these things because I'm just laying out the facts and the information. I don't want it to be that way. I'm not trying to be a downer. I'm not trying to be critical. I'm not trying to, you know, I'm just laying it out like how it is. And I had said in the very first video, before I saw Kathleen's original motion, I had said that I believed it fell under the criminal statute. And it's just because I have read other cases in the Supreme Court where it has been a post-conviction motion, a 97406, and they have specifically said that some civil statutes do not apply because it is a criminal action. It's civil in nature. The procedure itself, it can be civil, but it's a criminal action. And so the criminal statutes still apply. When Kathleen filed her motion, I was like, hey, maybe I'm wrong. I didn't think I was, but I could be. You know, I could be. But that's always been my understanding of how the statute works. And yeah, and then, you know, and I had said in the first video I did that there's not a lot of case law trying to figure it out, specifically with this specific motion, with a 97406. It's hard to find anything about judicial substitutions with those statutes. So I couldn't even really, I tried to research to find a definitive answer, and I couldn't get one. So I was just like, okay, well, maybe she's got it right. I still didn't know for sure, but we'll see what happens. Well, then when the state came back, that was their first argument. That it's a criminal action. Even though it's civil in nature, it's treated like it's civil in the court procedures. No, it's that, okay, so it doesn't mean that you are against her because you don't agree with something she does. Well, I don't want to say that I don't agree with it. It's just that I don't always think that she's going to win some of the arguments she makes. She makes them sound good. She makes them really sound really good. But, you know, but I tend to go deeper and look at the law and the statutes. And I've said often, I would love to be wrong, you know. And I'm going to put this out there right now. Okay, some of my haters out there, I can't tell you how many times I've seen the comment that she thinks she knows more than KZ does. Really? I would love to any of those people to point out where I have ever said that, because clearly I don't. Okay, but that doesn't mean that there aren't times that I'm going to question things and say, hey, why did she do this? I don't understand. And when I'm questioning it, I'm not questioning it like, oh my God, is she an idiot? Why did she do that? No, I'm questioning it because I'm saying, I wonder why she did that. What don't I know? What am I missing? This is my understanding, and I would really love to know why. And trust me, most of the time I'd love to talk to her and say, hey, can you tell me why you did that? I'd like to know. But because I question her, it's like, oh my gosh, I'm against her and I'm this, and I think I know more than she does. Okay. I can't tell you how many times I've said, not a lawyer. Okay. So I have to laugh when I see those comments. In general, I've said I have a very thin skin. I don't like people picking on me, but sometimes the comments are just ridiculous. It says she thinks she knows more than KZ. Yeah. Point me to where I've ever said that, please. Yeah. Because haven't, wouldn't. So, thank you. Yeah. I'm just stating the law, and that's what I've been trying to do more and leave my personal like opinion on it out. And like, okay, here's the facts. This is what the statutes say. This is what the case law says. You guys listen and you decide for yourselves what you think. And I'm trying to stick to that. But people ultimately ask me what I think, and then I tell them the truth. I'm not going to lie. You know, and I would love for it to be different. So I don't have the state's objection open right now. I know that was the biggest thing. well, the other argument was that, you know, in the statute, no matter which statute you use, the statute does say that it's, you know, and there's an order for a new trial or a sentence modification, that you're going to have to watch it when I'm done. You missed a bunch. When, you know, when there's sentence modification, that's when you can ask for a substitute for a judge. And we're not at that point. And that was my biggest hang up with the original motion, was that we don't have that. We do not have an order from the Court of Appeals modifying the judgment, reversing the opinion of the lower court, and remanding it back for that reason. No, I do not think it was a stall tactic at all. No, not at all. They don't have anything to do with each other. So no, I don't think it was. So, I totally lost my train of thought. Sorry. So anyway, I just didn't think that, I didn't think that that she could overcome that very clear part of the statute. And you watch the other video where, you know, when I talk about her motion, where she talks about the further proceedings, and that part she's correct about, but it's like she's kind of still ignoring that first part of the proceeding, when it's like, yes, they are saying when there's further proceedings that if there is a discretionary decision that needs to be made, then you can request a new judge. But that still means after there has been a decision, after the appeal is concluded, whether you won or lost, or just they've made a decision and they're sending it back for further proceedings. Because you hear the case reverse, you know, the situation where they say reverse and remand. You know, that's what that is. They're reversing the decision and they're remanding it back to the court for further proceedings. So, you know, those are basically the two arguments that the state made, and those are pretty much the same arguments I made in my video when I said that I didn't know she could overcome that. Well, Kathleen came back with a reply today, and I need to open it. So give me a second here. Since my internet was out, we got a new router, and we don't have my printer hooked up yet, so I couldn't print anything out. So I have to do things on my iPad. Okay, so I'm just going to go through some of the areas that Kathleen brought up. And like I said, she makes it, you know, she makes a good argument. You know, it sounds good, but again, she starts off by explaining that it should fall under the civil statute, and she points out a couple of cases that are a parental termination of parental rights case and civil commitment case are the ones she cites, and she says that they use the terminology civil in nature, okay, and those follow civil procedures. Yes, but in those opinions, it also says they're civil actions. They're not just civil in nature, but they're also civil actions. Whereas Steve's case is civil in nature, but it's a criminal action. And the big thing is that they will say that you can default to using the civil statute when there is no other statute that applies, but there is a criminal statute for judicial substitution. So again, this is just my thinking on it. I don't know if it's correct or not. I'm just throwing it out there, but those are my thoughts on it. That yes, those other cases are also civil in nature, and they do use the civil proceedings, but they were civil actions. The civil commitment ones are criminal cases, but that's not what the petition was about. The actual action is a civil commitment proceeding, meaning forcibly holding somebody because they're sexually violent, I think is what the statute actually says. And then she brings up the Findorf case again, which is where it demonstrates what the further proceedings and when you're able to get a new judge. And I talked about that in the last video, and I said that is another case, and the state did bring this up in their objection. They said that case was remanded after a decision. It was not in the middle of the appeal. So again, I just still think that it probably falls under the criminal statute, but it could still fall under the civil statute. But to me, either way, I still think the problem is that there was no decision from the court. They're just remanding it back for fact finding. If there was a criminal case she could have cited, she would have. Yeah, probably. She probably had a hard time finding them too, because there aren't many. And I will tell you that the Chapter 980 and the TPR cases, termination of parental rights, are the most complicated procedural cases in the Wisconsin statutes. They always have their own set of rules and their own set of laws. It's everything you read is except in TPR cases, except in Chapter 980. So she picked like the ones that have the craziest procedural rules. It's yeah. So you really can't completely go by what they do in those cases. But I said I understand her argument completely, and I get where she's coming from. It's just that again, it would have been nice if there had been a case that is criminal in nature, a criminal action that is following a civil proceeding, or civil in nature, as they say. That would have been nice to see, because that would have been obviously a little bit more on point with what we're wanting. Okay, now this is the part that I get why everybody's confused about this, because even I was scratching my head at this one. The appellate court issued a remitter conferring jurisdiction back to the circuit court. Now, this one is confusing because the state said that, okay, first you go back to the Court of Appeals order where it said we are going to retain jurisdiction but remand the record back to the circuit court. And there is a record in the circuit court docket of them sending the record back down to the circuit court for fact finding. And they're essentially saying that the judge can rule, okay? And Kathleen made the argument that, well, the law specifically says that the circuit court cannot rule when they don't have jurisdiction, and the Court of Appeals doesn't lose jurisdiction until they file this remitter. I hate that word. I was just asking Wendy about it. Either. I always want to say remitter, but remitter. So you have two opposing arguments, and neither is really wrong, because the state is going by what the Court of Appeals said, which they did say that they are going to retain jurisdiction. And then Kathleen is saying that, well, the case law says that the circuit court can't rule. They don't have jurisdiction until the Court of Appeals sends the official remitter of the case. And I was hung up on that one too, because I was just like, neither is wrong. I didn't really understand, like, how can the Court of Appeals say we're going to retain jurisdiction, but then say the judge in the circuit court can make a decision on this case? And I knew that it was somewhere. I just couldn't figure out where it was at. I had to find it. And it turns out that what I consider to be the case that, or the statute that covers this, is in, let's see, it's the 808.75, 0.75, 808.075, permitted court actions pending appeal. This is where the motion for reconsideration and some of those other issues that the circuit court always has jurisdiction over come into it. And in Rule 5, it says that notwithstanding the limitations of the section, any party may petition the appellate court for remand to the circuit court for action upon specific issues. And then 6, it says, in addition to sub 5, the appellate court may remand the record to the circuit court for additional proceedings while the appeal is pending. And that's exactly what they did. So that is the statute that they followed, 808.0756, is that the appellate court remanded the record back to the court for additional proceedings while the appeal is pending, meaning the appeal is not concluded. It is still pending. And then it says that upon completion of an action taken by the circuit court under that subsection, the clerk shall send a copy of the judgment or order to the appellate court. So right there, it's saying that they can make a judgment and can make an order. And then the final subsection 8 says, if an appellate court remands the record to the circuit court for additional proceedings under subsection 5 or 6, the appellate court in the pending appeal may review the judgment or order that the circuit court enters following remand. If any party is aggrieved by the judgment or order of the circuit court, the party shall file in the appellate court a written statement of objection to the judgment within 14 days, whatever. Okay, so what that's saying is that the Court of Appeals has jurisdiction, because even though the circuit court judge is making the decision, they still have ultimate authority over it. They can review that decision. So I guess what it sounds like is going to happen, and again, I don't know exactly, but what this statute sounds like is that the judge can make her decision. That decision is forwarded to the Court of Appeals, and they will review it. Now, that doesn't necessarily mean they're going to review it for, like, whether she's right or wrong. They just might review it to see, do we need to give her back her jurisdiction so she can continue on? If she's going to deny it, they wouldn't need to. They would just forward the record. They'd have her notes on her decision. They would forward the record back to the Court of Appeals, and then all of that information that was presented in the circuit court would now be part of the record, and it would be added to the existing appeal. That's all that would happen. But if she decides to either add the CD to the record or rules on a potential violation, then if she tells the court that, then the Court of Appeals would have to give up jurisdiction back to the circuit court so it can be an official order and they can continue on with whatever relief they plan on giving, whether it be an evidentiary hearing, which would be the only realistic relief. They're never just going to overturn the conviction. They would have to have a fact-finding evidentiary hearing on these issues. So at least I'm hoping that I get it right, because I said I was confused by that as well. I was just like, I don't understand it, and Kathleen cited the case law where it says that, that the Court of Appeals, gives up jurisdiction once it files a remitter. And she was saying that Kathleen was essentially saying that it's an implied remitter because of the fact that, well, how can the circuit court rule if they didn't send the remitter? So yeah, I said I was hung up on that too, but that statute pretty much says that they can do it. It's under the heading of it's court actions that are permitted pending appeal. And it specifically says they can remand it back for fact-finding mid-appeal, while the appeal is pending. And they can still retain authority over it. It's just that the circuit court judge will still be making a decision. So now, when this motion was first filed, Judge SCOTUS would have had 7 days to act on it. She did not. Probably the best, decision for her to make, because it would have been just submitted for additional review anyway. I think Kathleen would have had 10 days. Numbers are just jumbled in my head right now. She would have had 10 days then to submit it to the chief judge for review. By Judge SCOTUS not taking any action, it actually just automatically got submitted to the chief judge of District 4, which I said it before should be Judge Barbara Key. We don't know, but she's the chief judge for that district. So that's who should be looking at it. The only thing that is not clear is the time frame in which she has to rule. I would assume that it would be similar to the 7 days. I don't know why she'd need much longer. She might need a few days after the reply, the objection, all that stuff comes in, but we shouldn't have to wait very long on the decision. And I'm just going to tell people right now, don't freak out. Don't freak out. Don't scream conspiracy. Don't scream corruption, because again, I'm explaining to you what the law is. Okay, and people are going to do it anyway. And I have a whole 33 people watching this video, so I'm still going to be around thousands of people that are going to be complaining about it. I'm just going to ignore it. I've gotten to that point where I'm just going to ignore it. I've tried. Somebody else tagged me in a post. They're like, can you help me out here? I'm like, it's a losing battle. I've commented hundreds of times telling people that's not why this is happening. That's not what it means. And people don't listen. They just want to scream and complain and yell and say everything sucks. And, and again, I've said before, I'm not saying that nothing is ever corrupt, because clearly I think there are things that are corrupt. I'm just saying that not everything is, especially when it comes to some of these court decisions. It's just the way the law goes. So yeah, I'm expecting a denial. Maybe I'll get surprised. Maybe they'll be like, no, that's right. She made the right argument. Again, I'm just reading it based on what I'm seeing. It doesn't mean I'm right. Doesn't mean I'm correct. Doesn't mean I know more than Kathleen Zellner. It's just my opinion on it. But again, don't listen to my opinion. I said the name of the statute. Read the statute for yourself. 808.075, subsection 6 and subsection 8 are the key ones there. And you read it. Read the arguments that are made by both sides. And that's what I want people to do. I mean, I want people to be educated on how to understand these documents, how to look up the case law, what case law matters, and how to read the statutes and understand what these arguments are, because most people read the documents and most people read the documents and then they just read them at face value. And I always say that every attorney is going to make it sound good. It doesn't necessarily mean that their legal arguments are sound. And that's for both sides. It doesn't, and every lawyer does that. I mean, they're not going to make themselves sound like they don't know what they're talking about. They're going to make a good case. Lawyers are great arguers. So they make the best case that they can. It doesn't mean that just because it sounds good that it has the best legal standing. And so that's what I try to do. I'm just trying to tell you what the laws are, what the case law says, with fully admitting that I could be missing something, misinterpreting something I don't know, and just let you decide for yourselves. So I think I lost people once I started talking about Chief Case. I know people get mad at me when I criticize anything. I'm not even criticizing. I'm just stating the facts of what this motion, what the facts are of this motion. But I'll be say that I'm criticizing. So whatever. I'm used to it. I missed the beginning. We'll watch later, but I assume you don't think he has a case on this issue. No, I don't. And I thought that from the first time. I mean, I knew about this. I knew she was going to file this before it even happened. I was told, and I told I said then, I was like, she's not going to win that. It's mid-appeal. I mean, you need to have a decision from the appellate court before they'll allow you to substitute. That was my absolute first thought. And then I kept waiting to say, like, well, maybe, again, something I don't know. But to me, it just is common sense that if you're in the middle of a proceeding and you don't let, one judge rules one way, that you can't substitute another judge. It just seems to be common sense to me, but apparently not everybody. Did the family talk to her or just Steve? I think the family does too. Maybe not as often. So, yeah. So I just want to know if there's any other questions. So far, nobody has come home and interrupted my video. Yay. And I'm sorry if I talked really fast. I just tend to do that. But if there's any other questions, ask now. You can't judge shop. And that's what I called it the first time I talked about it, was I said that it's like judge shopping. And it was funny, the state actually kind of used that terminology, but it's actually there in the statute. It's called that. It's saying that they don't want people to be judge shopping. And I'm certainly not going to fault KZ for wanting to get rid of her at all, because I said I don't agree. That is one situation where I did not agree with her decision. I don't think every claim that that Kathleen made was a winnable claim, but there were certain claims that definitely warranted, in my opinion, an evidentiary hearing. And before anybody freaks out about it, even Kathleen knows she's not going to win on everything. You only need to win on one. You only need to win on one claim, so you just make them all. And again, the Brady violation itself, still haven't decided how I'm going to handle that one. So we'll talk about that once she files her her supplement, which is due July 9th. So it's actually due July 7th, but that's a Saturday. So July 9th would be the due date. We might see it before that, but that's when it's due. Sorry, I hate doing that in front of people, but on camera, I look dumb, but I was choking. Do you think the CD is enough? I don't want to get into the whole thing with why I don't believe it's a Brady violation, but or that it's not as strong as it claims. I mean, they could still win on that. It's just that, to me, it's not as strong as people think. And again, people just look at it like, oh, they withheld something, therefore it's a Brady violation. It's not how it works. That would be easy. It's not quite how it works. So, but I don't really want to get into all that, because that's another whole video just talking about that. And I'm not sure I even want to talk about it, because again, I know people are going to be unhappy with me. How is it not a conflict of interest when she was also the judge that was overseeing the Hallbucks against Steve case? You'd be surprised at what they don't consider conflicts for judges. Judges, they always are working on the assumption that judges are impartial. They are always going to give them the benefit of the doubt that they are impartial, and that if they feel they can't be impartial, they police themselves, and they are the ones that should say, I'm going to recuse myself. I mean, it was a big issue in the last couple of years with campaign funds, and how some of the justices, or one of the justices in the Supreme Court, received a tremendous amount of campaign money and then ruled over a case that company was a part of, and it was not considered a conflict. Some of the other justices thought it was a conflict, and he refused to recuse himself. So that they've tried to push that through, and they can't even get that through. So, judges do not like being told that there's any even hint that they may not be able to be impartial. Egos, as usual. Why won't she recuse herself? She has no reason to. Like I said, there's no conflict. That is not a conflict at all. You have judges that work in one county. Okay, like the judges in Stephen Brendan's case had other family members, other people in front of them several times. The divorce proceedings, I mean, these judges are small county judges, and they have everybody in front of them. So if it was, you can't preside over a case involving the same parties more than once, you'd need a million judges. Yeah, so just handling another case with the same people, it doesn't make it impartial. It's usually the things that you would think of: a close familial relationship, any type of financial game, economic interest, things like that are considered an actual conflict of interest. So July 9th, we should be able to see KZ's submission. Yes, that should be when we see it. I said, I don't know if she'll file it early, but it is due on Monday, the 9th. And she should be presenting everything that she has so far. So we will see what that all is. Sandy, are you still here? I think that is, actually, now that you mentioned that. Somebody asked if July 9th is Steve's birthday, and it might be. I don't know if Sandy left. She probably left when I started talking about the other stuff. But I'd have to look. But yeah, that sounds like it could be. I know his birthday's coming up soon. Should be a good read. Yeah, I mean, it'll be interesting to see what she's all gathered over all this time. You know, we know that there's going to be obviously stuff related to the Brady violation. But what, in addition to what she's already said, I don't know. Not that many people here today. I think I can, but maybe because I kind of sprung it on you. I don't know. Usually I have many more people watching. So, anything else? I'm trying to think if there was anything else that I wanted to say. Yes, I know the family. Yes, I do. And how are the family doing? They're doing as well as can be expected. I got to see everybody at the rally. Steve's parents are hanging in there. You know, they're doing the best they can. They go about, they go about their days. I mean, that's what they have to do. And obviously they want to see him home. Thanks. Okay, so that's it. Thank you guys. That's not helpful for me trying to like say things in this video. But okay, well then I'm gonna wrap it up. So if there are no other questions, the next video, unless something weird happens, will probably be when KZ files that supplement. And then I will probably discuss the Brady violation stuff then, as much as I don't want to. But again, I'm just going to lay it out. I'm going to lay out the information. Do with it what you want. All right. Okay, then. You guys have a good night, and I will see you soon, hopefully with my laptop prepared, and I won't look so weird to myself. All right. You guys have a good night.